Welcome to the Real Estate Podcast and Agent's Guide. I'm your hostess with the mostest, Ashley Jabora with Jabora Realty Team, brokered by Blair Realty Group. Remember, everything we say here is for educational purposes only. Please do your own research and make sure to verify rules and regulations in your area. So today we have Clint Neighbors of the Neighbors Team.
Hello again.
And we have John George of the TREC Broker-Lawyer Committee and Special Provisions. Thank you so much for being here.
I'm excited about it. Thank you.
Would you like to give like a little introduction about yourself?
Sure. Well, I've been a practicing attorney for about 17 years, I think now. I'm married to a broker of 20 plus years. And she always told me to stop being a lawyer and help me get this deal closed. So it really pushed my legal career into the residential real estate side, especially. That is a little bit unique. And I've had a lot of experience of owning a title company, of being on the Broker-Lawyer Committee now for, I think, 8 years.
Yeah.
I'm currently the co-chair and just love it. I love and geek out on everything contracts, compliance, and in residential real estate.
And we love that about you.
Awesome. Yeah, I told my wife this morning what we were doing. She's like, that sounds terrible. Like, I love this stuff. I love the legal side of things.
I do too. It's so fun. So kind of jumping right in, I kind of had some like broad topics and then I have two kind of specific situations, not situations, but just two questions to be answered. So I'd love to hear from you. What are your top 3 common legal issues that you see agents run into?
Top 3 legal issues. Right now, definitely paragraph 12. Paragraph 12, the 2402, in not filling it out correctly, not knowing what to use, in making mistakes by not pausing to figure out exactly how I should do this.
So for people listening that maybe aren't as familiar, because we do have people out of state even, so what is the 2402 and what would paragraph 12 refer to?
Sure. So we had a lot of changes, of course, with the NAR settlement that came down that required different written agreements. In Texas, realtors here in Texas came out with the Form 2402 that really replaces the old MLS agreement. It's a cooperative compensation agreement. At the Texas Real Estate Commission and the TREC Broker-Lawyer Committee, we revised our contracts here in Texas to have a provision that allowed a seller to contribute to reimburse a buyer for their buyer agent fees. And they're coming from 2 different parties. You have the 2402, the cooperative compensation, which is being paid by the listing broker. And then you have paragraph 12, which is actually being paid by the seller. It's not really being paid, it's being reimbursed to the buyer there. And so I think there's a misunderstanding of how those two interact.
Yeah.
And it's a fairly new concept that we put into our contracts here in Texas that we never had the ability for a seller in the residential single-family home side or 1 to 4 family home side to be able the ability to contribute. Right. It was only in our farm and ranch contract. So having the agents not understand that, sometimes they put it in both blanks. In the 2402, which goes on our page 10, and then the paragraph 12. And so they're doubling up on the potential legal obligations for the payment of money unexpectedly.
So that means they could end up getting double compensation if they wrote it that way, with both blanks having say 3% in each one. It'd be 6% instead of 3%. So they're unintended consequence of not knowing how to fill out the contract.
Exactly.
Yeah. So as a listing agent, you definitely want to pay attention to that if it's in 12 and a 2402.
And it's such a core component of what we do. It's something that we as agents, and I'm an agent as well, we need to pause and think about it.
Yeah.
Anytime that you're filling out those 2 blanks or using that form in paragraph 12, it's time to take a pause. What are we actually obligating ourselves or our seller to do in that case?
Well, and it seems like they changed the form several times through the process, and until we finally landed on that, it'll probably change again. So I think there's confusion. Agents, they're like, well, we were doing it this way, and I'm confused of what we're actually supposed to do and which forms. And then you get people that maybe they haven't sold a house in a year or 2, or it's their first one, and they really just don't understand it because they're not, going to class, they're not, learning their contracts, and they're guessing. And, no, if you don't have a good mentor or you don't have someone checking those contracts, I think that's where we're seeing a lot of these mistakes coming through.
Absolutely. And we have another situation on the horizon with Senate Bill 1968 that just passed. Nobody's really talking about it. But we're in that same situation where we're about to have more changes come out. And now's the time to get ahead of it, to understand it, to help develop the practice, to develop the forms. to fit the situation. So we don't run into this 2402, another form we had here in Texas, the 2406 from the Texas Realtors that was revised several times. This new issue of Senate Bill 1968, which we may or may not be able to get into, now's the time to get involved to make sure it gets done right first time, right? To make it understandable and everybody will know about it going into it instead of trying to learn after it's in place.
Right. And, as from the brokerage standpoint, we try to get ahead of things. Yeah. And it's just so hard to get everyone to show up and, and to do the extra classes and, and actually pay attention and try to learn some of these things.
Yeah, I'd say as my primary role is working with new agents, that is the most frustrating because agents kind of lose their steam and then they're out of it for like 6, 9, 12 months. And then they come back and they're like, wait, what is this form? What are we doing? And I'm like, oh my God.
And they're like, I have to get this offer in 12 minutes.
Yeah, I know, exactly. But I do want to also address, because some agents still not realizing about the 2402 is they're just using page 10. And I mean, it literally says on page 10 that is not binding. And I think it's what scares me is agents are like, no, I put it on page 10. It's fine.
Yeah, that is very scary. And it's a good reason why last week we suggested another change to the commission. I say we, the Broker-Lawyer Committee, suggested a change of deleting it. And so we try to do that. It was maybe 3, 4, 5 years ago. At one point, we recognized this on page 10 for everybody that doesn't know these contracts. It's a disclosure that allows the listing broker and the buyer's broker to list the amount of cooperative compensation between the two of them. Right? But the brokers are not parties to the contracts.
Right.
So this is a separate agreement that's just referenced for everybody's ease of knowing whatever the brokers are paying each other.
It's kind of a reminder that, hey, make sure you got that form filled out.
Yeah.
So we took it out because if you had one amount in the old MLS days and then a different amount on page 10, there was confusion on which one controlled.
MLS.
Because absolutely. Yep. But the contract was the first and last in time. So everybody thinks, no, I put a new amount in there that controls. And so when we suggested originally take it out years ago, the pitchforks came out saying, how are we going to know what the commission is?
Yeah.
And it's like, well, that proves our point. It never told you what the commission is.
Right.
You had to go to the MLS agreement. And now that that's gone, it's the 2402 that absolutely will control.
Yeah.
So you and I had a conversation the other day about that, and agents are now attaching the 2402 to the contract and they're writing it in. And you said, no, don't. Just stop doing that. It's making us a party to the contract.
Yeah, there's several different issues that arise with that. One is it's not intended to be an addenda, right? The brokers are not parties to the contract. And once you attach it, you're making yourself a signatory somewhere within the contract. Because remember, a contract addenda is part of the contract. It's one and the same. We call it an addenda in some separate form, but it's one and the same with the overall contract. Now, the legal minds will debate on how much liability arises out of that or not having liability, but it creates an issue and an argument for lawyers to say, hey, maybe you have expanded liability beyond the terms of just the 2402. And past that, let's say it gets sent with the contract and everything comes back signed but the 2402. Do you have an enforceable agreement? Do you give room to argue for the other side to say we want out and we never had a contract to begin with? Or then are you breaching your fiduciary duty by not signing it?
Right.
But let's say you have a broker that doesn't want to do cooperative compensation, meaning they're not going to do the 2402, but it's put in the contract. And then you're in the position of, I'm not signing that. And then it goes back to that same thing of, well, do you have a contract to begin with when everybody else was agreed on the term? And so it was intended when it was developed by Texas Realtors to be signed in advance and to make sure that it was established just like the MLS established it before. And the problem then was that you have all these 2402s floating out there because you're signing in advance of a contract that may never come to be.
Yeah.
And so then as a broker, you're having to manage that. You're having to keep track of it. What are the terms of it? When does it expire?
So does the broker have to have a copy of all of them that are out there, or just the agent?
It's the broker, absolutely. Sales agents operate only under the broker. They're sponsored by the broker. The broker's the one that's actually the party to all these agreements. And so the TREC rules here in Texas require the broker to keep records, within XYZ category, one of which is the compensation agreement. So the broker, it's actually the broker's record. It's not the sales agent's record. It's done on behalf of the broker.
So I would imagine a lot of brokers probably are not handling this properly.
Yes, absolutely. There's no question about that. And I think brokers need to step back and pause, and sales agents need to realize what they sign what's the agreement between the broker and the sales agent? Most brokers are using the independent contractor agreement from the trade association. And that allows sales agents to sign contracts on behalf of the broker. That's why you have sales agents signing listing agreements, buyer's reps.
Right.
But you have to pause and think about that authority. Are you training your agents up enough to understand what they're signing? Do you understand that they're binding you as the broker in all these things that they sign? And so it's really important to look at that paragraph, especially the what we call the ICA, the independent contractor agreement, to make sure both the broker and the sales agent understand the scope of that authority and who's actually being bound and whose records those are.
Yeah, no, that makes complete sense.
It brings a thought just quickly, little tangent, with the buyer representation agreement that we have to have before we show a buyer. We cannot open a door without this agreement now under the new ruling. Would that document also need to be at the broker level, or does it just need to be in the file with the agent? Because, we check a box when we're showing in the showing service that we have an agreement. And I guess my question is, do we need to be putting that somewhere else? Does the broker need to have a file with all of those to stay compliant as well?
Well, it can. A broker can have a sales agent maintain the records, right? So it doesn't have to necessarily be physically in the broker's office, right? As long as it's being maintained by the agent and kept, and it's a minimum period under TREC rules that you have to keep it for at least 4 years. Okay. There's good reasons to do it for a lot longer, but it's also creates some risk when it's only with the sales agent. Because what if the sales agent leaves? What if all of a sudden they're unfortunately hit by a bus or something? Let's say the dramatic case. Where are those records? There's no exception in the TREC rules and TREC requirements, the Texas Real Estate Commission requirements, for the broker to say, well, they just left and they burned it, or they got upset. There's an example in the broker responsibility materials of a broker, I think, dating an ex of one of their agents, who then left and deleted their whole, the whole cloud drive. Yeah. And the broker can't go to TREC and say, hey, I can't give you this record because this agent got upset at me for dating their ex, right? But that's realistic. That happens a lot. Unfortunately, you don't have a lot of, there's situations where you don't have a good breakup, right? There's good reasons. Hopefully you can leave on good footing, but we know it happens all the time that agents leave that are upset. And when they do that, it's going to be really hard to get those records back. Yeah. Or just by innocent mistakes. Yeah. Accidentally deleting it, or my laptop, fell in the pool when I was trying to work on vacation, like a lot of us do. So systems need to be put in place. Yeah. On the broker level to ensure those records are kept. And it scares me from the risk side of having it only on a sales agent's laptop that I'm not aware about. You really need to think about that in advance and develop policies and procedures around it.
Right, for sure. Well, and like our systems that we use, you can only archive, you can't even delete, but it doesn't, we have more experienced agents that come in who are using like forms and things like that from Texas Realtors where, it might only be on that system where they didn't put it on our system, even though it's in our policies and procedures that it's to go on our system.
Well, and let's think about this in the modern age. I like to think about what's coming up, what's next, how are people communicating? One of the things that have to be kept are substantive communications. Right. And then I give the example of, gaming. There's some gaming systems that, that some of these agents are getting clients from. And, they're spending all this time gaming. And then they all might start talking about in the chat about this particular transaction or that particular transaction. And those are substantive communications.
Literally
about the
never
transaction.
thought about that before.
But this is where you have to sit back and pause and say, how am I operating? Let's look at the rules. And y'all are so energetic. I love it exudes from you and into your agents and gets them excited and to think about these things. And that's what we need more of. Yeah. Brokers is engaging and thinking about these things that, and that just hit me about the gaming, 6 months ago. It's like, wait a minute, there's a lot of communication because my son had 3 kids, a 15-year-old, 13-year-old, and 8-year-old. But they're all on these systems and they're all talking to each other. And I'm not a big gamer myself, but I was just looking over on they weren't talking about the game. They were talking about life. They were talking about this. And then it's like, wait a minute, agents are doing the same thing. And I started asking around. That's
so fascinating.
And several agents have told me, yeah, we do it all the time. This is one, how I get business, and 2, how we communicate.
That's a Y2K conversation you need to have with them. It
is. And my daughter, it's funny, she was at Sam Houston and just graduated, and she was president of the gaming club.
Go Bearcats. Yeah. I'm a Bearcat too. Okay.
And she was on Overwatch team, and that's what she was saying. She like, all of our conversations are through the games, and then there's some apps they're using because she's always sending me screenshots screenshots of conversations. I don't even know what it is. It's definitely nothing that I've ever seen. So there's a lot of different communication methods out there that the younger guys are using. And I don't know if it records things. I don't know if there's a history. And it seems like the younger generation, they delete all their conversations after they have them is what I've noticed. Like if I go through my kids' phones, they're blank. So
wonder why.
And it's just a habit they have, and probably to hide things. But as they get older and they become realtors and things, if they maintain that habit, they're getting rid of all of the substance.
So that's the exciting thing about, we can learn just as much as either as legal or you as the brokers. We can learn from the sales agents and the younger generations just as much as they can learn from us.
Yeah.
Right.
And the gaming's an example. I've never thought about that, but just by being engaged and thinking about it and in creating the environment, the excitement, as a broker of having this conversation, compliance doesn't have to be scary, doesn't have to be boring.
Yeah.
Right. It is something that we can make it lively and spin in so many different ways in terms of, staying out of trouble, but then gaining business and how to comply in a way that's not burdensome. And there's a lot of different thoughts and a lot of different programs, a lot of different ways that can streamline those things. But it's a good conversation to have on a both directions. Both from sales
so how
agents
would
us.
you log that conversation on something like that?
It depends on the program. And it depends on I'm not sure the gaming side, because I'm not the gamer, on how I know some of those are archived, some aren't, and we're not required to record every conversation. For example, let's say we pick up the phone, we're not required to record it, and in fact, some states you can't record. But so it's a line that's not necessarily black and white, and you have to look at exactly how the communication is done, what type of record there is. If a record's created, you have to make sure that you maintain it. Sure. If it's not keeping a record, then I would, in a lot of cases, there is no requirement. You don't have to proactively create a record unless it's something that you want to, right? That conversation that's being done on maybe a chat that just goes away, just like an oral conversation that somebody might, conveniently forget later. You never told me that.
So they should have maybe an activity log or make a note of the conversation at least and put it in a file if it's going to be a client that they're working with.
It's especially important conversations. Those are things that if there's something that we pops in our head, this may be an issue later, or this is a disclosure problem or something that just be thinking about it and let me document it. Even if it's my,
as they're shooting someone in their game.
Yeah, exactly. Well, and this is where you can get too far, right? This is where you don't want to get overly submerged where you don't have to. But at the same time, we want to comply.
Yeah.
So this does give me like a whole nother thought. As a coach, I'm always coaching to the younger guys, and they're asking me, how can I connect with people? How can I have conversations, and how can I grow my business? And I'm saying, do things that you love, go join groups. I haven't even thought about the online gaming.
Yeah.
That's what they do, and that's where they talk. And I need to incorporate that as one of the things, because it's voice to voice. They're doing what they love. People, their guard is down. They can have these connecting conversations. It's a great place for them to go and try to expand their business.
Yeah.
Our business is so much about trust. And when they spend so much time together, there's a trust, even though they could be complete strangers, right? A lot of them get to know each other in those platforms. And so I think it's a great opportunity that, the older generation may or may not be involved with, right? Sure. And it's a great way to connect.
Yeah, I love that. So we started this with the top 3 most common legal issues. So we hit on paragraph 12, compensation. I kind of dare to say that communication is probably where a lot of people, like, not keeping track of their communication, maybe like another major issue they find themselves in. What's another common legal issue that you see that agents can hopefully prevent?
Misunderstanding agency. And that goes to whether it's intermediary, whether that's I'm representing the buyer or seller in different situations, and understanding who you represent and the nature of that agency relationship.
Yeah.
And this is where there's about to be a sea change in Texas too, that is coming January 1st of 2026. It's a huge change that nobody's really talking about yet. And so if we look right now and under current Texas law before January 1st next year, if you're doing any real estate brokerage, you have to represent somebody. Right? If you go open up a door, you're either representing the buyer or you're representing the seller.
Now, this only pertains to sales transactions, not tenants, landlords?
If no, same thing.
Oh, okay.
So opening up a door is, if you're looking for a lease transaction, then yes, that you're
'Cause right
representing
now
somebody, a landlord or a tenant.
Yeah. Okay. Yeah. Because right now it's really to sales, right? It's buyers and sellers, but it wasn't really addressed as far. NAR didn't really address leases.
Right. In the new
And now
rules,
Texas is.
yes and no.
Okay.
Yep. And so this is where there's a lot of minutia in this law, and this is, we can get out ahead. So if we look at NAR, what did NAR do? NAR came out with a written requirement that before you can tour a home with a buyer, before you can show a home, you have to enter into a written agreement with them that sets out certain terms. And what Texas has done is similar but different. And it also only applies the one particular section to whether before you tour a home, or it adds an element before you submit a contract on behalf of a buyer. You must have a buyer's rep.
That's the component that was really mind-boggling to me, that we did not have to have a representation agreement to send an offer, but to open a door we did.
And so Texas has filled that gap. I always say, and I joke around, that Texas has one-upped NAR. Now, there are different requirements, and there's a lot to it. So this initial discussion here, know that there's more behind it. And there's other rules that apply in all transactions. So that specific rule, which is going to be Chapter 1101563 of the Occupations Code, if anybody wants to geek out and go look at it.
Sure.
So it's TRELA, part of the Texas Real Estate Licensing Act. It's what the government tells us as agents we have to follow.
Yeah.
TREC makes rules underneath that. TREC is an agency. It's separate. It's not the legislature. It's an agency that then makes rules, and we know those as TREC rules. And so this new written agreement that's required has different trigger points in NAR. But there's another rule too, that's 562 right before it, that creates something that is, you can open up a door and not represent anybody. That's a huge change. All the way up until now, before we've had sub-agency. And this is where it goes into the biggest problem that I see with agents not understanding agency. Let's say that a broker is listing a house and they can't do the open house. So they get somebody from a different brokerage to come hold it open for them. Right? And you get a lot of agents thinking, this is a great way for me to try to get buyer clients. But if they're holding open that open house for the seller, they're representing the seller. Even though they didn't have a direct contract with them, the listing agreement, they were there on behalf of the seller as a sub-agent of the seller. But at the same time, a lot of motivation behind doing that is to get buyer clients. But you have to remember, when you're there, you're representing the seller, which then creates these minimum duties that are in confidence. That you put your client's interest first, which is the sellers, not the buyers. And if you gave any advice or opinions to the buyer when you're holding open those open houses, all of a sudden you have intermediary. And in Texas, we have very strict intermediary rules. And you have to properly establish it. You have to get consent. You have to do X, Y, Z things. And then there's tenants that you have to operate under. And if you don't establish it right, you intermediary without appointments, you can't give any advice or opinion to either side.
Right.
So that's where I see the mistake, not understanding who you're representing.
Yeah.
And with this new status coming out with Senate Bill 1968 of you can represent nobody potentially, which again, it's a huge sea change. It repeals sub-agency. Sub-agency is going away.
Right.
And you're either going to represent buyer, seller, or nobody. And when we represent nobody, there's new rules around that as well.
Is there a new contract for that?
There will be.
Okay.
And so there's going to be potentially 2 new written agreements that are required. A non-representation agreement. And so before you open up a door for anybody, you're going to have to get
just created one.
Signed.
Lynn was like, I'm so glad I spent $1,000 on that.
I've been working on that for a while.
There's always something new. And so we, as the Broker-Lawyer Committee, I say we, I'm not speaking on behalf of the whole Broker-Lawyer Committee today, but just me and my role on it. But we elected at this point not to suggest to the commission a TREC form. We have never had a buyer's representation agreement. We have never had a listing agreement. We're not prohibited from doing it, but we haven't gotten involved in the private business dealings of listing agents or buyer's agents and their clients. And the trade associations have been the ones to develop those forms. The listing agreement, buyer res, we had long form, short form.
So they're all TXR forms.
They're all TXR forms, so Texas Realtor forms. But brokers can have their own. And this is where it's expanding that I love to hear that, you have your attorney developing your own, right? It's not cookie cutter. The business is changing.
Yeah.
The relationship, what works for one broker doesn't have to work for the other. Gone are the days that everybody practices the same way, especially on the buyer side. You can have such wide-ranging types of representation, whether you're just opening up doors, whether you're just writing the contract, whether you're doing XYZ services. It's no longer this generic concept of having no agreement in many cases, which then what are you actually doing? And you didn't set the bounds of your representation of that buyer. So effectively you were taking on the full scope.
Yeah.
And there wasn't a clarity between the buyer. What are you actually doing for me? And so a lot of these rules in place are now going to require a clarity around those issues. It's going to require you to enter that written agreement and to think about it. But at the same time, so we'll have new association forms at the very least. I am a big proponent of looking at this from the TREC side. In fact, I spent a lot of time drafting an agreement to potentially propose for TREC to adopt. And I've won some people over already. I was, out of 13 members, I was the only one that really was pushing for it. Let's get a draft together. And after discussing the concerns at the last meeting, a couple more came over to say, I'll help with that effort. And there's good reasons. I can make arguments on both sides, even for me. And I'm on both sides of the fence. But it's something to look at. But unfortunately, we will have new agreements. And it's time for everybody now to get involved.
Yeah.
Because they're not out yet. It's not done until January 1st. Texas Realtors has not drafted them yet.
Okay.
In the forms committees, there's a form committee meeting today actually in Austin for Texas Realtors. And they're looking at the listing agreement specifically. But between now and next year, they will have to have a new buyer's rep to account for the new law. And they'll have to have a brand new form that's going to be a non-representation agreement come out.
I think that's a great idea.
Yeah, I like it.
Because we decided as a brokerage, we don't care for intermediary with no appointments. We it's just too sticky. And you're right. Like agents don't understand what their role is in those. And naturally, we want to give advice. We want to help people. And so, that's why we decided to adopt a non-representation agreement.
Well, people just respond. If someone asks a question, they respond. And the agent would respond. And it's like, wow, you just broke the law.
Yeah,
you didn't even realize
exactly.
You're trying to be nice and have a response.
And that's the scary part about intermediary without appointments, because you can't give it to then either side, advisor opinions. And with this new non-representation, it's going to operate the same way. There's three things you can confirm: price, terms, and size. It's I believe I'm getting those right. The three things that you can actually confirm. And it's the same thing as the unlicensed assistants in the current rule. If you go to the TREC rules on unlicensed assistants, the same three things are listed. But that's all you can do. Since you're being friendly and you're just helping out, giving and answering a question, you're going to cross the line. And what's different now with this new Senate Bill 1968, there's TREC enforcement behind it. This is now a licensing issue, and it goes into the provision of the TREC rule saying if you violate it, TREC can suspend or revoke your license or do other disciplinary act. Where before it was NAR. And there was a question of, well, if we didn't have the proper buyer rep, who's going to come in and what's the penalties for it? Yeah. Who's policing it? Title company, the brokers, the NAR?
So in practice, nothing was happening.
Exactly. But now it's going to have a true enforcement thing for your license itself. Right, TREC is going to be behind the enforcement of this, and TREC generally is not a product. They're not going out and look for issues.
Sure.
But if a complaint is made, it opens up the box. Yeah. They ask for all your business websites. They ask for your IBS. They ask to see the CPN. They ask to go check all these different things that may be completely unrelated to the complaint made.
Right.
Could be that crazy client from the other side that's just mad at everybody and files a complaint. And all of a sudden, if you don't have the right buyer's rep in place, then your license can be in jeopardy.
You'll at least get a slap on the wrist or a fine or something.
Exactly.
And so listing agents get this a lot. So price, terms, and size, what happens when a buyer calls us and they're like, can I see the seller's disclosure? Does that fall in that category? Can I still provide that? I mean, I'll tell you I want to.
And so it providing documents may not necessarily be advice or opinions, but it definitely blurs the line, right? They're asking and you're starting to provide more. Some of these things are going to be gray. And that's where the talking about it in advance of the common situation and seeing, is this okay? To really think through it. And if we look at the nature of the new rule is you have to, when you sign this agreement, there's tenants, and I may be getting ahead of myself here, but the tenants say you can't be exclusive. It can't. It has to terminate within 14 days. It has to provide clarity on the exact services you're providing. And once you give that seller's disclosure, let me go start pulling some things for you.
Yeah.
Or some comps, right? Your seller's disclosure. Well, what the prices of the surrounding properties? That's starting to get pretty clearly on the brokerage services side.
Right.
So that little thing of the seller's disclosure that could just be a form, now all of a sudden becomes a little broader question, right? You're doing something more on behalf of that buyer.
Yeah. So what about at an open house? Should we be, because usually agents take it to the open house so that when questions are asked, they have the disclosure that's right there. Should they not have that at an open house?
And this is where you have the clarity on who you represent. Right now, you have to represent somebody. And if you're holding up an open house, you're representing that seller. And absolutely, you can provide the form.
Okay.
Right? Because then you're the seller's agent. And so your duties flow to that seller. You have to not only provide the seller's disclosure, you have to tell the buyer about any material information you know about the property.
Right.
In fact, that goes to both sides no matter what. As agents, even your client says no, you have an obligation under Texas law to disclose any material issues.
Okay.
And so that's pretty clear. And under the new rules, even if you're there holding open house for the seller, you're representing the seller. You're not going to have a buyer's rep or this non-representation agreement because you're holding it open for the seller.
Yeah.
But in that case, you still have to disclose the seller's disclosure. You have
Right.
to do that because it's the duty that you owe
That
to your
makes sense.
seller client.
And I know in our trainings, we're hitting that pretty heavy, that know who you represent. Just because you're trying to get a buyer from it does not mean you can act as the representative to that buyer unless you get a buyer representation agreement with them. Then you can cross over to that line.
Right. So what does that look like for the future of open houses with the SB 1968 for agents outside the brokerage hosting an open house?
And this is one of the biggest questions I have. And yesterday I was talking about that pretty thoroughly back and forth. Is going to create the situation where clarity in agency, the biggest problem, one of the big three pillars that I have of mistakes, is going to force clarity there.
Yeah.
And if you don't have sub-agency, no longer can you just come underneath the listing agent or listing broker to hold open that open house. Your agreement is going to have to be with the seller.
Yeah.
Right. And there's no current written requirement for agreements with seller clients. Right. You can't on either side enforce a commission obligation if it's not in writing against a buyer or seller. But beyond that, that's just enforcement. That doesn't mean you can't have an agreement with them. That's not in writing. But it no longer can you just go through the listing broker. I mean, you're going to have this conversation somehow with the seller. And we don't know the answer because this is brand new.
Yeah.
But this is part of what we need to be talking about now that maybe we can address in the forums so we don't have to figure this out the hard way in practice.
Yeah.
But we can't even talk to the seller. Like if they're under a listing agreement with another broker, we can't go have a conversation with the seller as an outside agent to talk about, would you give me compensation to hold an
Or do you get something signed from the seller saying like, hey, this other brokerage is going to be hosting this open house who does not represent you? I mean,
Yeah.
Well, and there's some minutia there too, and just not to give the wrong impression. And because the TREC rules, right? There's separate ones under NAR and separate ones under TREC. TREC rules don't say you can't go talk to a seller when they're under a listing agreement. You can't negotiate a listing agreement when they're under exclusive agency with another one.
Right.
But you can negotiate for it to start after that current agency ends.
They have to reach out to you first.
Not necessarily in that case. I mean, but if you go under NAR, it's different. NAR has the higher burden.
Gotcha.
But if you look at the specific TREC requirement, in any case, you want to be professional and you want to respect that
Sure.
agency. But the having to reach out in that conversation on how it's done to provide it to we're going to have to think about how to incorporate it. I don't have the answer to it, but I know the collective thought, this industry, the agents, the boots on the ground we need to rise up to talk about it, to think it through, and how do we want to address it?
yeah.
And can we put it in the form? If it's not in the form, let's at least get it out there with the reliable sources, whether it be Texas Realtors, TREC, or somebody else to have the discussion so we have the same understanding. We don't have to revise quickly the forms or put out new FAQs to address things as they pop up. We have 5 months before it comes into to enforce on January 1st.
Yeah.
Let's figure these things out now if we can.
Yeah, no, totally agree. Another one that I wanted to hit on was misleading information, words and phrases that agents use that can get them into trouble.
Being definite on things in not qualifying, unqualified representations, unqualified statements in general. And I make a silly example of this of, say, the wall here, that wall is white, right? That's a definite thing. Or instead of saying,
It's actually agreeable gray, so it's not white at all.
Yeah, it's kind of grayish.
But instead of saying, Clint said that wall is white. That is one of the biggest mistakes. That's if we take it to a different level of, this house doesn't have foundation issues. Instead of saying, my seller told me this house doesn't have foundation issues. And that's a huge distinction.
Yeah.
When you come into a lawsuit, there's all these protections built up as agents because we're not expected to be, and the law doesn't say we have to be experts in foundations. It doesn't say we as real estate agents and brokers have to be experts in appraisals. We're not appraisers. In fact, we can't. We're not contractors and all these things. We might be on the side or be married to somebody who is or has some general knowledge. But in our practice of real estate and under real estate brokerage, we're not required to be those things. And once we step in to say this house doesn't have foundation issues, we get outside of all these protections that are built in because now it's our own representation instead of something that our client told us that we're just passing along. And so if we pass along, we put it in writing that we got this from the seller, we have rules in place to say we can't be held liable for that. Mm-hmm. But then you say it's just this, no foundation issues, that wall's white, and that's wrong. That's in your own representation.
Right.
Yeah.
So there's a few things that I hear a lot, like new roof. Mm-hmm. So I see it all the time. They put new roof. Well, once the roof is installed, technically, I would say it's probably not new carpet in the house. Well, people walk on it. Now it's dirty or goddamn. Now it's not new carpet. So from a legal standpoint, I don't ever put that. I put roof installed, May 2025.
Right.
Is there a liability there you're taking on by saying new, or whatever the thing is?
I would say I love the lawyer answer there of this is when it was installed because that's correct, right? And if we look at these things of saying new, it puts us in potential liability realm. But I'm a big proponent of practical versus legal, right? Mm-hmm. And things could be legally wrong, right? You can say new and it may not be technically right. How much liability does it create? And so I'm always conscious of that because we can't live life in fear. We can't, live life and these minute risks. Could there be a situation that pops up? Absolutely. Mm-hmm. And so if you can be clear and you think of something like that, then yes, go ahead and use those things. At the same time, I know it's on the practical side. We're not going to say every time you walk in the room that the seller told me and give something in writing, they told me that was white. You're not going to do that every time, even though that theoretically could be an issue somehow with some lawsuit.
But what level of risk?
So just say white-ish.
Yeah.
Right. Yeah. But that's how far it can go, right? Where's the line? And I had to get out, and I have a lot of good people behind me, especially my wife, is saying, stop being a lawyer, right? We have these warped brains that if I'm trying to argue for my client, and I'm mostly on the defense side, but let's say you were on the plaintiff side trying to fight over that, I can come up with some arguments. You didn't say, let's go the new thing. You said it was new. Is it new? It was installed 6 months ago. Okay, what if I said it was installed a year ago, 2 years ago? When does it stop becoming new?
Me a roof 8 years old was new. So
oh Lord,
you just never know.
And so where's that line? And that's why it can be legally troublesome.
Yeah.
So the other big one I hear, and I see this, is when we're marketing ourselves, and I'll hear people say, we're in Fairfield right now, a Fairfield marketing expert, or I'm an equestrian expert. And I have heard we should not label ourselves as the expert in those things. Even if you are, it just opens yourself up. Mm-hmm. I've heard we should only say something marketing expert if you're going to use the word expert. What's your opinion on that?
So expert in real estate, I'm a little, back my mind's going to the bar, right? And so with the legal rules, to start there, a little more stark. We can't claim ourselves to be experts in a way that if we don't have designations, these special designations in certain areas. When you look at real estate, we don't have these as strict of rules as saying you can't say, X because if you don't have XYZ designation. At the same time, we can't mislead. And so it comes down to misleading. And I think context really matters. And describing yourself as an expert, how true is that? Who's going to be arguing it at the end? And so this is where that, to me, is what context is it being used? How much actual liability could be created, or confusion really could be created by that, because that's going to be, I think, the analysis at the end. Mm-hmm. Did you confuse somebody? Did you mislead somebody by using that statement? And how much do you have to actually back it up? So if there's another way to state, there's so many different ways to state things. If you can not use expert and use something else, safer. But that's one where's that line in real estate? It's not as stark as in some other professions that might be out there. And I look at it, there's a legal concept of puffing, versus, an actual misrepresentation.
Right.
How much much as the puffing part versus an actual misrepresentation that misleads.
Now, would you say like certain things that maybe can help in situations like this, like information from other sources or seller's authorization to release and advertise certain information maybe would kind of help in these kinds of situations? I mean, I don't want the seller to tell me it's a new roof and it's an 8-year-old roof. I'm just not going to be comfortable saying that because I feel like I'm being misleading. But maybe like the seller's authorization to release and advertise certain information, I think that's the TXR 1412, maybe could help an agent in that scenario if there's certain things that the seller wants you to say.
Yes. And I look at this as have a bucket of big ticket items, right? Of roof, foundation, all these things that they may tell you. And there's forms available for it. I received this information and I'm telling you in writing of where I received it when I hand it over to you. And if we look at plumbing, electrical, these things that are the higher ticket items, the ones that are litigated a lot, that's where it would be good to have let's think about this and maybe I provide that form because then that could fit within that exception of the TREC rule of you don't have liability for another party's or your client's misrepresentation, and your client doesn't have liability for your misrepresentation unless they knew about the falsity and didn't disclose it. So when you put it in writing, you get that out. You get that protection under the law that says if you put it in writing and told them you got it from that source, then it's not your representation again, right? That it's qualified by I got it from this person.
Yeah. So we created what we call a homeowner checklist, and it's something our team uses, and it has list out all of your upgrades and put the date or the year that it was done. So I guess that would qualify as that extra information that we're going above and beyond to show. So if we did say something in the listing that it was new or newer or recent, then that would qualify it as an exact date, maybe to cover yourself a little better.
Well, the important part too is making sure that gets to the buyer side, right? Or the buyer's agent. So we can have that internally, and it helps show where we got that information to back us up. And,
so we post it on the MLS with the disclosures.
Yep. And so I think that's good. And having the conversation with the client so they understand that's happening, right? You're not necessarily required to provide this information, but it'd be helpful for marketing and for us and walk it through. And as long as you have that full conversation of what you're doing with it and why, then I think that's great. Okay. Right, because then it's something in writing from the seller that you're putting out there. So it removes you as the agent from being in the middle. And I think we put ourselves in our client situations often too much, right? We're there to do stuff on behalf of the seller and not us doing it. Personally, we're the advisors. We assist them in selling and marketing their property. And so when we put things out there as our own statements and don't have those qualifications of just passing things along, that's where we get in trouble.
Okay. Good distinction.
Yeah. Definitely. Okay, we may have covered this when we talked about agency, but one of the other questions I had on here was what are some of the biggest issues you see regarding conflicts of interest with agents?
With managing it within a brokerage and knowing, I say active management to know what everybody's doing. And when certain, crossover clients or, certain information that's confidential from one that then is shared with others when it was really that client's confidential information, that's where I see that becoming an issue. And whether that's depending on the market, whether you're in the luxury or other ones, a lot of times you have even some NDAs that are signed that then you're even restricting disclosure of certain information. You still have to disclose things required by law, and you have to be careful when you do that. But there's this TREC rules that just have a general confidentiality provision that say you can't share the confidential information of your client. And so when you have these situations where in the brokerage, maybe they have access to other files, other things and transactions that are truly the seller's confidential stuff. And then all of a sudden it's shared with this other client. You have to be very careful on that. And I don't think that's thought about that much. It's more in I think legal minds and law firms of segregating things and conflicts of interest checks and things like that are mandated. We don't have mandated conflicts checks or so then we don't in real estate. So then it doesn't bleed over to these thought processes of situations where it might be an inappropriate sharing of confidential.
So one that comes up, divorce. In the seller's disclosure under lawsuits, I guess divorce is listed in that. And my question is if they have gone through a divorce recently and it's finalized, they're not in the process of that lawsuit or legal proceeding, whatever you call it. So can you disclose that it's a divorce situation versus if they're in the middle of it and they haven't come to terms, that is the legal proceeding? Because how is that disclosed on the disclosure, and what can we or should should we relay? Because that could be information that can be used against them, where a buyer would be like, oh my gosh, they're in a divorce, let's lowball them. They might need out of this thing. And so how does that factor?
So we had to step back to set up the situation first of who are we representing? Are we representing both husband and wife or not? And you can't sell until a divorce is final. Typically, you need both still to sell the property. Correct. And so if you're listing the property on behalf of just one or the other spouse, right, you have a problem because you're not selling the whole thing. You're only selling that person's undivided interest in it. And they are subject to, even though they're confident they're getting a divorce, the other side said you're getting it, until the court signs off on it and that order becomes final, is subject to change.
Yeah.
And that's a material issue with the house, right? You can't advertise them selling the whole thing when they don't have the authority to. And so that has to be disclosed on what you're selling.
So they're in the process of divorce.
This is where on the front end we get ahead of it by talking to our seller saying this is something we're going to have to disclose to buyers. And now may not be the right time to list it. Or let's get your husband on board that he's also listing this as well. And that could remove the issue.
That is the most common that I see is they both sign and they're in agreement, but then it's can we disclose it or should we? So if they're in the process of the proceedings, yes, it has to be disclosed. Let's say take it one step further. It's done. The divorce is final. It's recorded. Now it's his house, and I'm only representing him. She is off of it. It's been filed. Does that change it? Where now we shouldn't say and don't have to say anything about divorce because it's beyond it.
So I'm going to start with the TREC requirement. The TREC disclosure requirements come out of 5008 of the Property Code. There's nothing in there that I think would touch on that situation. And with the Texas Realtor forms, I actually haven't even thought about taking it that far to post-divorce disclosing that, because that's something that's dealing with the property in a way that I need to go back and look at that language. It's not coming to mind exactly how that is, but it doesn't immediately ring a bell as something that would go in that blank. But put a big asterisk on that because I haven't looked at that particular issue in the seller's disclosure.
Okay. And then I had a little bit more of a kind of specific overt question, not like a broad question. So we talked about the 2 days minimum communication when dealing with a transaction. What happens when an offer goes to your spam and you just don't get it, and then the agent thinks you've just not communicated?
That could be a problem.
Yeah.
So we had to have processes in place, and by not responding within 2 days when something's sent, it's not a very good argument to say just went into spam, right? They later make a TREC complaint. I think TREC would look at that as a reason. I think that spam is used so much as an excuse by a lot of people saying I didn't respond because it went to spam. If you can truly show and document or some way, I think TREC would take a lighter look at it in the surrounding circumstance. Is that your first time this has happened? It's not a common thing. It was understandable.
Yeah.
And the one thing to keep in mind with TREC rules, it doesn't, and this is a slightly different context but important, a violation of TREC rules doesn't necessarily invalidate the underlying contract. It creates disciplinary issues with TREC in your license. And so this comes up a lot with using the inappropriate form, right? So if you use a vacant land form or unapproved property form when you have a structure or a house on the property, it doesn't necessarily make that agreement not enforceable between the buyer and seller.
Yeah.
But you as the agent or license holder could be subject to TREC discipline for failing to do it. So going back to the offer side, it's a little different context, but it's the discipline level. That the complaint will be made. You didn't respond in time. It doesn't. That's really the impact of it.
So do we have a duty to check our spam every day and actually go through it and make sure that everything is in the right folder?
I would argue you do. I mean, that's the one to.
I don't like that answer.
Hey, I do. I like 5 times a day.
Yeah, I mean, but we know. We can't stick our head in the sand. We know things occasionally go to spam.
Yeah.
And it's something we need to build around. Now, if you've had this awesome, email that it truly kicks out the real spam, you never had any issues, can you argue something different? Maybe. I haven't heard this case come up about the spam with a complaint to point you to something to say, here's how it's looked at.
Yeah.
But I think it's so generally known that a lot of things it can end up in there, especially from unknown parties. And a lot of these agents use email accounts that are tied to not your common Gmails or Outlooks or whatever it might be. And so, with that knowledge, I think it's almost imputed that things could end up in your spam.
So the prudent thing to do, I guess, when you send an offer, you should follow it up with a text or a call and say, hey, I sent it. I want to make sure you received it. So, the other agent could have done that in that case and probably should have. But there's still a duty to check and make sure that spam is spam, you're saying?
I would argue it is. And this bleeds into the notice paragraph in the contract. Right? We recently modified that in our TREC contracts to add with copy to agent. Right before, it just had seller's information, buyer's information. And we did that because agents were all too often putting their information in there. And this comes to the spam thing, because what is a notice paragraph? That's where all legal notices must be sent. And if you put you as the agent in there, all of a sudden you're the one that's getting the notices. And if it goes into your spam and you don't pass it on, you just put yourself right in the center of liability by not passing something on, breaching fiduciary duties by not doing it. And I've heard that story a lot of it. Notices going into spam or you're away on a weekend and don't receive it. That happens quite a bit. And so in that case, it's good to put where the seller or the buyer wants the legal notices truly to go, whether it's to them, whether it's to their attorney, whether they have a POA, a power of attorney handling a transaction for them. Have that discussion up front. That discussion is not had enough of where do you truly want something that legal that comes in to go.
We really should have it go to multiple places.
Yeah, so that actually brings me, paragraph 21, right, is notices.
Correct.
So how should we be explaining that to our sellers?
So this is where if the other side wants to terminate the contract, the other side wants to give you notice if you're in a backup that the first contract terminated. This is where any notice under the contract must be sent. And this really, as the agent, I need to be copied on and keep you informed. But do you have counsel? Do you have somebody else that should get this? They should always copy me on it, but it really needs to come directly to you. And this is where it becomes a little sticky too. If we go take this a little bit further, of let's say you're sending a notice on behalf of the client, a notice of termination, notice of something. You need to send it where it states in paragraph 21, even if that is to the other side's client. That feels strange,
It
right?
does, yeah.
It's like, I can't communicate directly with them. No, you have to follow paragraph 21. And if you're giving a legal notice, it needs to go to whatever's in there, including if it is the actual client on the other side.
Yeah.
So I keep seeing the sellers are not filling that out. When I send an offer over, they execute it, they send it back. I have all of my buyer contact information there in mind. So could you even argue, do we even have a contract if they're not filling out a very important piece of the contract? I mean, that sounds like a pretty major thing that needs to be filled out where notices go.
What if the agent's name is in there and that is what the seller wanted, is just the agent?
That's probably okay, but
You're saying it's completely blank.
They don't put anything.
I don't think there's a lot of risk if just that term is left out of it not being an enforceable contract. Courts generally look at that as, are the material terms there? Can I discern the parties thing? It's just, because you don't necessarily even have to have a notice provision in an enforceable contract. It's great to have it there to remove ambiguity, but if you don't have it, I don't think it would invalidate the whole thing.
So if it's not filled out, where are we sending? Just the agent, I guess?
Well, then, so even if it's filled out and you send it to the wrong place, there's still an argument in the law that says the seller's information was in there, but I sent it only to the listing broker. There's an argument, and a good argument, that that's still effective because you're the broker's agent.
Right.
And so all the law changes. The law is not definite. There's so many different things that, especially in residential real estate, they don't get litigated. There's not a lot of relatively a lot of money compared to the cost of litigation.
Sure.
Involved in residential real estate. So you get a lot of these little issues that may not have been directly addressed in this context. So we're left as attorneys and lawyers to go try to find analogous situations in other contractual contexts. To bring it in, and that goes through the whole host of different things. And there's so many different little issues in residential real estate, especially that aren't litigated, that don't have any precedent elsewhere either. And so we're one of my favorite, and there's some analogous precedent, but a big one is the missed closing date. There's a big dispute right now over what's the impact of missing the closing date. Does it give the other side the right to terminate the very next day or not?
So what is your
What's the answer to that? Don't leave me hanging.
So this has been a soapbox issue, and I don't have a fix for it. There's a difference of opinion, I think, between the courts and legal scholars and even on the Broker-Lawyer Committee. And I think the last poll I did this on Broker-Lawyer Committee, I may even be in the minority in my position. But I think my position is backed up by case law and is backed up in specifically case law in our area where we are now in Houston. And so the contract states that if you miss the closing date, the party that didn't default, right, didn't miss it, can exercise the remedies in paragraph 15, which is the default paragraph. What are the remedies in paragraph 15? If the other side defaults, the seller or the buyer, one of the remedies could be to terminate the contract and receive the earnest money if you're the seller, or you can terminate the contract as a buyer. And so the contract is seemingly clear. But there's an argument that that's fake news. In that the side that says that you can't terminate necessarily right away, they say in some cases you can, but not necessarily, is you have to look at the materiality of the default. How big of a deal was it? Whose fault was it? We don't want, and I feel the bleeding heart argument, because I don't want a buyer to have a seller be able to terminate the contract just because the title company said we're closing down at 5 o'clock. They were there with their check ready to go, and they said, we haven't received the lender docs yet, so we're closing, you can't close. I feel for that buyer. They're otherwise ready, and later on that same day, all the docs are sent and it's ready to go. It's just because the title company wouldn't open up the doors to close the deal. But that's not what our contract said. And so we have a case out of Houston here, the Moody National case, that it involved a situation where the buyer didn't bring, the title company said you had to send a wire for the closing funds. They brought a cashier's check, and they said, no, you can't, we're not accepting that, we're not closing. They said, buyer said, that's fine, I'll tee up a wire tonight. And it was ready to go the next day, and the seller said, nope, you missed the closing date, I'm terminating. Oh my gosh. And the court upheld it. At the end, the seller won. And it involved our TREC contract, and they said that the contract unambiguously states that if you miss the closing date, the other side can terminate. But that's only case law. In Texas is unique. We have 14 courts of appeals that govern their little areas of Texas. Mm-hmm. And it's instructive in other places, but not necessarily binding until the Supreme Court, the one Supreme Court rules. So that's a ruling here in the Houston area. Wow. And there's a couple other rulings that are along the same lines, but not everywhere in Texas. Wow. And the Supreme Court could very well reach a different result. And if we look at other issues of, let's say you wrote in, hopefully the client wrote into their attorney that, these things would be done in the contract. And my favorite example actually was a case involved my wife. It was one of the arguments was the air filters weren't replaced and the contract required it. So the buyer said, I'm not closing. And there's other issues involved. Mm-hmm. But should a buyer be able to refuse to close just because you didn't replace the air filters? And why they didn't
was it in an amendment?
Contractually.
It was an amendment.
Yeah.
But the reason they didn't do it is because the painters were there until late, right? Mm. And they didn't want to put in these new filters with this dust and paint that the last few things they were doing. But in that case, if you look at it in the context, is that material, right? There's not necessarily you can argue the same kind of default thing, but in a different context, you have to look at that if that's material. And what's the remedy? How harmed is the buyer? What's the ability to get the seller to do it? How likely is the seller to do it? There's all these legal factors that gets really legal on that. But that's one of the things that just highlights that there's great minds, great legal side, and I can kind of take both sides on that, but I'm pretty sure I'm right on the closing date one, at least here in Houston. But it can be argued about. And that's where we put it on my agent hat. We can't tell buyers and sellers what the legal rights are.
Yeah. Even
on an issue that's that important, there's a disagreement between the top legal minds that are thinking about it, and potentially between the courts. Well, so how can we say you have this right or not when it's subject to all these legal concerns that we as agents are prohibited from advising them on?
I always just say you're contractually obligated, and then beyond that, they're going to have to talk to an attorney about what the ramifications can be.
I think it brings up the point of you need to have a good relationship with the other agent. You need to keep everything clean through the whole process. You don't want to give that seller or buyer a reason to be angry. Mm-hmm. And so I always say, never burn a bridge. I always try to keep things moving along, because I may need that agent to convince his seller to extend one more day to keep us legally into contract. Right. But if you're being a jerk through the whole thing, or your client is, I can see, I've seen it where it's out of the principle of it. They're like, I'm not going to close this house now because I don't have to, because I don't like that buyer anymore. Yeah. And you as an agent, don't let the other agent know that your buyer is saying all these things. Yeah. Maybe, I think there is a level of professionalism, and you have to have some common sense in it, and play politics a little bit through the process to make sure that we can get all the way through an extended closing.
Yeah. Yep. No, I usually do keep the jerk comments. I'm like, no, I'm the sponge that needs to absorb that. Like, you don't. That. Yeah, exactly. Like, you don't. If they don't need to know that, then I don't tell them that.
Type it out and then delete. But always put in our client's interest first. Yeah. Our fidelity to our clients. We always have to think about, is this in our client's best interest? Advise them on it. Let them make the decision.
Well, thank you so much. I felt like that was all really good information for our agents. Do you have anything else you want to pitch, even though Legal 2 starts in about 10 minutes? All right. Well, thank you. We really appreciate your time, and just love your enthusiasm for all things real estate and legal.
Well, and same back. I feed off you all. It's so great here. You provide such a great environment to your agents and the training, and it's a model for others to look at in terms of how a broker should operate and how a broker should provide the educational opportunities to the agents, and not just provide them, but get excited behind them. And y'all's excitement just just exudes from you, and it excites me. So thank you.
Well, we appreciate you.
Definitely. So again, I'm Ashley Jabora. We had Clint and John George here. We are Blair Realty Group. We're in the Houston market. If you were looking for an agent or a great brokerage, give us a call at 281-698-0240. I did not even let you give any special provisions information so that people could go follow you. Could you do that?
Oh, absolutely.
Let me just throw that in right now.
So specialprovisions.com, you can see we're just now started to launch. We provide CE classes. In the future, we're going to provide insights into the contracts and in some self-help legal services.
You've had us on the edge of our seat on that for a long time now.
And it's something that is so difficult as we've been going through today on the minutiae. We have to make sure we get it right and don't provide misleading information or incomplete information. Incomplete's just as bad as having completely wrong information. So we're working on making sure it's right, but we have some great CE classes that we're offering now. And
you're
really
on YouTube and Facebook, right?
Yep. Have a Facebook page. We do what we call the Agent Legal Lounge on YouTube. So check us out.
Yeah, I was on your Zoom yesterday. So remember, everything we say here is for educational purposes only. It's always a good idea for you to do your own research, and remember that most real estate laws are state specific. And lastly, do not forget that knowledge is your greatest asset in real estate. Stay educated, stay proactive, and as always, keep hustling.